Democracy, a think tank focusing on national security, foreign policy. Her work at FDD focuses on China policy. Ms. Delabriere also is the co-founder of Horizon Advocacy, a consulting firm focused on the implications of China's approach to geopolitics. Welcome. Mr. Julian Ku is the faculty director of the international program at the Maurice A. Dean Distinguished Professor of Constitutional Law at the university's Maurice D. Dean School of Law. Professor Ku's research is focused on the relationship of international law, the U.S. Constitution, and China's relationship with international law. I think Mr. Bradford Muller has been well introduced, and we're thrilled to have you here today. And lastly, we go to Mr. DeLille, thank you, DeLille, who is the Stephen A. Kozin Professor of Law at the University of Pennsylvania. Professor DeLille is also holds appointments as a professor of political science and director of the Center for the Study of Contemporary China at Penn. His research focuses on China's engagement in international order, law, and legal institutions, and their relationship to the politics and policies of China and the U.S.-China relationship. We welcome all of our distinguished witnesses, and pursuant to the committee rules, I would ask that you rise to take the oath. Customarily raise your right hand. Do you swear or affirm that under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief? So help you God. Thank you. Please be seated. Let the record reflect that all witnesses answered in the affirmative. For all the witnesses, please be aware that although we ask that you stay within 5 minutes, your entire opening statement, along with additional material that you either have today or that you can supplement, will be made in order and a permanent part of the record. I thank you, and Ms. Delabriere, it is not Briere.
Thank you, Mr. Chairman, Ranking Member Johnson, and distinguished members of this committee. Thank you for this opportunity to address what I call China's asymmetric lawfare challenge to the United States judicial system. I just want to define lawfare as a term for us to understand here. Lawfare is the systematic use of judicial proceedings to accomplish strategic or military goals, political goals. This involves manipulating legal processes to undermine, discredit, or impose substantial financial burdens on adversaries through judicial mechanisms. The Chinese party-state lawfare demonstrates consistent patterns. Initiating entities maintain ostensible independence from the Chinese government. Chinese plaintiffs often retain most prestigious, the best U.S. law firms to represent them. And even if their litigation is often in the preliminary phase and it will impose substantial costs on defendants. I call these tactics asymmetric lawfare because China is exploiting the weaknesses in its own legal system to gain advantages in U.S. courts, while the U.S. and U.S. plaintiffs cannot reciprocally use China's legal system for its own strategic goals. These tactics that we're going to discuss here can only really be employed by China and never by the United States. And China's lawfare raises particular concern because China's unique control over its private sector through state-owned banks, Communist Party cells, and United Front partnerships means ostensibly private Chinese companies are vulnerable to being co-opted to serve the party state's political goals. Now, I want to give two examples of what I call Chinese party-state lawfare to illustrate the problem. The first case is from Long Island, where I'm from. It involves Ma Ju, a Hui Muslim activist who has testified before Congress and the UN against China's repression of his ethnic minority within China. He was served papers in Nassau County Court in New York State seeking enforcement of a $12.5 million judgment that was issued in China. Ma claims that this judgment was fraudulently obtained and that he couldn't defend himself before fleeing China. Despite this, the court in Nassau County ordered Ma to pay the full $12.5 million court judgment based on the Chinese court's ruling. This is not isolated. U.S. authorities have identified at least 7 similar lawsuits filed by Chinese entities over 6 years, with 3 under FBI investigation that's reported. And more broadly, Chinese companies have increasingly pursued commercial litigation in U.S. courts as plaintiffs, not as defendants, and often against Chinese nationals who happen to also be wanted by the Chinese party state for either claims of corruption or maybe for political opposition to the party. So that's one example, I think, of the kind of lawfare that we're up against. Another case from California, Mao Zedong's, the former chairman of the Communist Party, his secretary, Li Rui, became a prominent critic of the Communist Party at the end of his life. And Mr. Li agreed through his daughter to donate his personal diaries to Stanford's Hoover Institution. And after his death in 2019, though, the widow of Mr. Li in China filed suit in Beijing claiming ownership of the diaries. The Beijing court ruled in Ms. Zhang's favor, ordering Stanford to return the original diaries despite Stanford's attempt to defend itself. And Stanford argues that it received inadequate notice in Chinese courts and was denied an opportunity to contest when it tried to appear. Ms. Zhang, who has recently passed away, but sued in U.S. court alleging copyright infringement and seeking title based on the Beijing court judgment. The U.S. trial court allowed some of her claims to proceed, and the case has dragged on for over 6 years, 5 to 6 years. And it demonstrates, even if it doesn't result in a positive judgment or a successful judgment for Ms. Zhang, it demonstrates some of the ways in which the Chinese party state uses lawfare for ideological purposes beyond just harassing opponents. Furthermore, it raises a different problem, which is Ms. Zhang was very unclear the sources of her funding. She was a widow without any sort of obvious means of wealth, and she funded a 6-year massive lawsuit in California courts, which went on for years, which Stanford has the resources to defend itself, but not all U.S. defendants would necessarily be able to do so. So I want to close by discussing some possible legislative solutions. One would be taking on the American Law Institute's proposal to change the rules in the United States for enforcing foreign court judgments to require reciprocity before enforcing a foreign judgment, or at least change the rules to require foreign someone like defendants to essentially allow defendants a better chance to defend against Chinese court judgment enforcement. And finally, I think there are things we can do to bolster disclosure of foreign funding of litigation through third-party litigation or through amendments to the Foreign Agent Registration Act to address litigation funding. These reforms will protect American courts' integrity from manipulation by the Chinese party state while preserving what makes our legal system exceptional and valuable. Thank you for your attention.
Thank you. Mr. Mueller.
Chairman Issa, Ranking Member Johnson, and members of the